Welcome to Iowa. Welcome to Prairie Meadows, and welcome to the 2024 National HBPA Annual Conference. I'm Dr. Doug Daniels. I'm president of the National HBPA, and of the people that are here that put their blood, sweat, and tears into putting this together, my contribution has been comparatively little, and I admit that. But that all said, I'm looking forward to a really eventful panel discussion on the HISA situation here shortly. I want to thank the Iowa HBPA for hosting and for sponsoring our reception last night. I want to thank Mr. Dennis Alba for hosting at his incredible venue. It's just an amazing thing to experience. And with that, I'm going to pass to John Moss.
Thank you, Dr. Daniels. Again, just want to emphasize, really appreciate everybody coming to this conference this year. It's been over 12 years since Iowa HBPA has been able to conduct a conference, mainly because of the summer situation that we all know is very difficult for affiliates to come and participate in. But we're really appreciative of everybody taking the time, the panelists that are going to be here in attendance. We think you're going to have an outstanding conference. The National HBPA team always does a fantastic job putting together the different panelists that come and give us a very vast variety of informational topics that are vitally important to every one of us as horsemen all across the U.S. So really, really big thank you to the National HBPA, Eric Camelback, the rest of the team. But again, just want to reemphasize, thank you for coming to Iowa. Really appreciate everybody coming out. Those bottles of bourbon that you have, a special thank you to the Iowa HBPA Board of Directors. We wanted to do something that was a little bit different. Vice President Joe Kelly was the one who came up with the idea, and that is our gift to you in your bags this year. So please do not get drunk during the panels with those bottles, but nonetheless, they are there, and we really appreciate everybody coming out and have a really great convention, and we'll see and talk to all of you throughout the rest of this wonderful time here. Thank you.
All right. Well, again, welcome to everyone. We appreciate everyone being here. And, before we bring up the first panel, just have a few thank yous that we want to get through. First off, we can't do this without our sponsors, whether it's our corporate sponsors or whether it's our affiliates who help fund this directly through National and allowing us to put this on. Obviously, we can't do it without you. Let me first just thank Kentucky Downs. They were the sponsor for our breakfast this morning. We appreciate everyone coming out. Glad that you're here, but I want to roll through our sponsors first just to make sure I thank everybody from the corporate level, but then individually all the sponsors that have helped with panels, that have helped with breakfast. We'll be having them on the screen and also thanking them before each. But from our corporate level, let me first start with Sterling Thompson. Our friend Kevin Lavin, who started the owner-trainer liability program many years ago, long before I was around. They've been a serious sponsor for the National HBPA, helping us promote the owner-trainer liability. A lot more racetracks are going to that certificate, and it's helped fund National. So we really appreciate them. Horseman's Tack and Equipment, Mr. Randy Block, who came on a few years ago, based out of Louisville, helps a lot of racetracks get some equipment, but certainly is there as a good advisor and also helps horsemen when he can. SIS, Michelle Fisher's here. She's been a longtime supporter, close friend. Certainly I bend her ear probably more than she wants, trying to educate myself on a lot of topics, but we really appreciate SIS coming on as a corporate sponsor. Dr. Blanchard and Finish Line Products, we have this kind of neck and neck with our other corporate sponsor, Miss Susan Martin in the back. Equine Line and Finish Line have been right there sponsors for the National HBPA longer than anyone else. So along with Dr. Blanchard, Susan, thank you for being here. Again, a friend. Wes, her husband, kind of tags along. He's trying to find the nearest golf course, but that's okay. Also, Horseman's Labor Solutions. Everybody in here knows Will Ville. He is usually here. He's usually a mainstay for our benefit providers, whether it be the breakout or the panel. He's got a family wedding, so he's unfortunately, I think the first one he said in a long time, not going to be here, but always appreciate his sponsorship. Twin Spires, with our connection with the Claiming Crown and dealing with Churchill Downs, Twin Spires really stepped up, not only helping at the conference last year, but now stepped in as a corporate sponsor to really help ultimately promote Twin Spires betting platform, and then also help with the publication of Horseman's Journal. Crims, one of our newer sponsors as well. Gunnar LaCour will be here later this week to talk about Show Me the Money. At the end of the day, we think his service is well intended. We think his service is certainly something we all should be looking at, whether it's him or not. He'll tell you we need to know where the money's going and how it gets to us. Also the DRF, we've got a great relationship with the team at DRF. There've been some changes, but Mike Jameson, who has been very instrumental in helping us run ads for the Claiming Crown. He basically has, his news feed on our website, anything we need, including racing forms, which obviously if Rick Hiles doesn't get his racing form, we all suffer. And lastly, and certainly not least, Steve Anderson in the back here in the bright yellow. So he's definitely incognito. Steve's been a longtime friend of the Horsemen. Whether we talk about his days at the NTRA when he started with Joe Morris and they pushed initiatives to get horsemen breaks in various things that horsemen need. Steve went out on his own and has developed an amazing company, Equine Equipment. Please stop by, see him. If you have any interactions with your racetracks and their maintenance crews and their track superintendents, please talk to Steve about progressing through Equine Equipment and getting horseman discounts. So thank you again to all our corporate sponsors. If I could kind of get a hand on that, I'd appreciate it. So again, our national sponsors for the conference, certainly won't read through them all. They are in your proceedings book. We've got everyone listed, but obviously from each panel, each breakfast, we could not do it with the funding that we have, and very appreciative of everyone who helps put on this conference, whether it's an affiliate or my new friend, fellow polo player, Will back here with AmWager. We couldn't do it without you guys. So thank you all for helping us put on what is going to be a great conference. So thank you. All right. So with that, I will start to introduce the first panel. All right. So hopefully it stays like this. We're already 5 minutes ahead of schedule, so we're doing good. So the first panel coming up today, we appreciate everyone who has been able to get here. Obviously, we've had tremendous travel issues trying to get folks from, well, quite frankly, most everybody out of Atlanta, and my friend Brent, who couldn't get out of California. But at the end of the day, there's been a tremendous amount of effort for everybody that has gotten here, and we do appreciate that. So first, let me certainly thank the sponsors of this panel, the Indiana HBPA, who's been quite instrumental, President Joe Davis, who sits as a regional vice president, the New England HBPA, still instrumental in trying to bring horse racing back to the state of Massachusetts, and then my good friend, Dr. Harrington with the Alabama HBPA, and we're lucky enough to have Nancy Deloney here. Thank you guys for helping sponsor. So obviously, HISA is a topic that everyone has been talking about in this industry for quite a while. So it would have been odd for me, probably, I feel, not to start off with a panel discussion on where we are. What's the status report with the Horse Racing Integrity and Safety Act, some of the litigation, some of the problems. So again, we're not here debating whether HISA is right. And I got some nasty media emails, wanting to know where certain people were on the panel. And this isn't we've already been through that, right? This is a where we are now. And I hope a Q&A for anybody in the audience. I know we've got some lawyers also in the audience. If there are questions, now's the time to ask them. So let me bring up the panelists. First off, I've got Mr. Peter Eckebert, who's going to be the moderator. I'm sure everyone knows our general counsel. Next on the screen, to my left, your right, Brent Malmstrom. Brent is an executive, but he is an owner. He is a breeder, has really put KAM racing on the map through claiming, but in this presence of the HISA status report, he's got some very detailed issues that he's going to go through, and Peter will explain a bit more. We also have a face that's become familiar to all of us now, who's also become a good friend, Daniel Sir. Daniel now is the founder for the Center for American Rights, but was at the time lead attorney with Liberty Justice when we set out on this journey of litigation to begin with. So we're really happy to have Daniel join us again. And then also Pete Sakopoulos. Pete, aside from graduating from Tulane, which, you know, as an LSU graduate, I've always got to kind of get that jab in there, but Pete's become a good friend, all the way back to Indy King, the Stallion. Pete is an attorney. He's a very good attorney. He's written an amicus brief for some owners in Texas. He is the general counsel for NARV, North American Association of Racetrack Veterinarians. But at the heart, he's a horseman. He's an owner. He's been on the Breeders' Board in Indiana, and he has always been there to help protect horsemen's rights, and he is continuing that fight. So we're glad to have these panelists join us. But before we get into that, I just wanted to say a few words, because at the end of the day, today is a new day, right? We have a new constitutional opinion that's come out, and you know, HISA has become this, I've said it once before, our industry's new four-letter word, right? The Horse Racing Integrity and Safety Act. But I also want to say something that I think everyone in this room knows and appreciates and certainly believes. The National HBPA had the same mission a lot longer than HISA, right? We wanted national uniformity. We've strived for national uniformity. We even supported the RMTC in an effort to do it in a scientific fashion. So the mission's the same, and we appreciate that. But when we started down this path after the bill was signed into law, I felt as if I made it very clear publicly in the media, the stance of the National HBPA is and remains to do our due diligence to protect horsemen, right? That's what we're doing. We're pursuing this because there was a concerted effort to review the act, and we did not feel like it was in the best interest of the horse. I've made the statement publicly that I had a call standing on, like most trainers, standing at the rail on my cell phone, pretending like I'm training a horse at the training center. I'm talking to an attorney on the East Coast, very prominent attorney. And I asked her, what would be the first thing you'd do if you had someone who got a violation under this new law, if it goes into law? And she very frankly said, I would challenge the constitutionality. And she spilled into a very detailed brief of the due process issues and many of the same issues that Pete Sakopoulos has brought up really since the beginning as well. So that got my mind going. Okay, we want uniformity. We want everything on a level playing field. We want cheaters out of the game, but how are we going to do it in the best way possible to protect horsemen? And is this act the right thing to do? I think now we can justly say this act as a whole is not right for horsemen, the horse racing industry, and it's not doing what is necessary to protect the horse. I said this the other day, as many of you know, especially my friend Jenny Reese, I say a lot of crap off the top of my head and then don't remember what I said. I was being interviewed by Steve Bick, one of the casualties to our conference due to travel. And there's a lot about winning and losing, right? Did you win? Did you lose? Are you going to win? So in our world, my world, I'll say my world, right? What is Eric? Eric is football. Eric is polo. Eric is horse racing. And it's a black and white. You win or you lose. I was brought up the son of a 20-year career Marine. Long before Ricky Bobby, he told me second place was the first loser. So that's the way I've always thought about it. You win or you lose. You can't think of that now in this fashion. I've morphed, I've understood and tried to grasp. So I'm going to give you an analogy that really just kind of popped off the top of my head in this interview. Everybody in here is taking a driver's test, right? I hope. If you take your driver's test and you fail, it doesn't mean that you got every question wrong. You can get things right. You can have some safety regulations that are good. You can have some positive medication rules that are good. But if you don't get it all correct, you fail. That's what HISA is doing right now for horsemen. They're failing. 3 constitutional opinions have been rendered against the act. One of which, done early on, when everybody said the act was constitutional, they changed something. So obviously they were incorrect. It wasn't constitutional to begin with. They made a twist. They made a statement. They made an amendment. So it became constitutional in some opinion. Now we have 2 more opinions that render parts of the act unconstitutional. Therefore, it is not as a whole what's best for horsemen. That's what I want everybody to understand. It's not about winning necessarily. It's not about losing. You know, we can win this round in the courts. We have to wait and see what comes up next. But it needs to be a complete act. It needs to be what's best for horsemen. And it needs to be what's in the best interest of the horse. And it needs to protect the industry. I don't think if you're true to yourself, anybody, even outside this room, can 100% say what's going on right now is in the best interest of the entire industry. And that's Eric's opinion. Peter, I'll turn it over to you. Make sure your mics are on. You got to turn the switch at the top. There you go.
Okay. Oh, good. Okay. Success. Yeah, just to echo the same thing Eric says is obviously if your constitutional rights are being infringed and taken away, that puts us back into a dictatorship, and we don't. Obviously, that's what the whole revolution was fought over, was to have our rights and be able to function. So this fight, I think, is a good fight for all, and hopefully will continue to be successful. We have 3 speakers here, including myself. That Brent Malmstrom will be our first speaker, and Brent will share with us his efforts on behalf of horsemen and the personal experiences that he's had to endure at the hands of the unconstitutional enforcement program of HIWU. Then Daniel will get into the 5th Circuit decision that was rendered July the 5th, holding that HISA was unconstitutional because of the delegation of executive powers to a private entity, and discuss what this success means for us and where we go from here. And then Pete Skaskopoulos will discuss the case pending before the 8th Circuit and what that means and what the potential results and options may be with respect to that case. And then finally, I'll come back in to discuss the current filings or current litigation that have been filed in the courts just within the past week, as well as some of the other Supreme Court decisions that have evidenced a trend by the Supreme Court to limit administrative agencies and the powers that they exercise, which is all bodes well for our fight against HISA. So, and then finally, we'll have a question and answer period for specific concerns that you may have. So to start this off then, Brent, turn it over to you.
Thank you. Greetings. My apologies. I tried to move heaven and earth to be there, but I am a victim of the latest airline debacle. I know it's really unfortunate for me is, first and foremost, my name is Brent Malmstrom. I own a technology service and cybersecurity company in the Pacific Northwest. I also have Microsoft and CrowdStrike as both of my customers. So it's been an eventful few days for me. I had 100 guests at the opening weekend for Del Mar. So I mentioned that only in the spirit of just to highlight my passion for this game. I mean, I brought out a bunch of CEOs from various Fortune 100 companies to experience Del Mar opening day, many of which had never been to a horse race before. And the enthusiasm and the excitement to see live racing in person at Del Mar was a really fun and enjoyable experience for them. The CrowdStrike CIO, I think he sat in the corner and wanted to continue to drink, and I shared his pain. And for Eric's comments at the beginning about a bourbon bottle in your bags, you might want to pop one out and have a little cocktail as I go through my conversation about my experience. And really what I'd like to emphasize is something that was brought up earlier about this notion of winning and losing. My experience so far has been that the optics of our situation appear to be that we have lost more than we have won. But the unfortunate reality is that we haven't been able to argue the fundamental issues that we continue to face and have with the situation with one of my trainers. And I also want to highlight that I took up this fight for one very specific reason. What I realized early on, and I actually wrote an article for those that may not know, but about a year ago, a little over a year ago, I wrote a letter to the editor that was published in the TDN, highlighting what I was seeing as my concerns, highlighting that there are fundamental, what I believe to be due process considerations and challenges, as well as just fundamental unfairness, where you can blatantly label somebody a cheater before they've ever had any opportunity to defend themselves. And back then it was, you were labeled and branded and suspended as a cheater before you even had the results of the drug analysis. It was only after you got the first adverse analytical finding on the A sample. They weren't waiting until they got the confirmation of the B before they were suspending people. Now, I understand the rules have all changed since then, but many of these changes have not helped our situation. And I also should highlight, I also took this case on mainly because, you know, I care about my trainers. They're family to me. I have trainers all over the US. I used to have roughly 30 to 35 horses in training at any given time. I've scaled it back because I don't really like what I see as what's happening. I see two fundamental issues with the industry as it exists today. There's the economic model, and that needs to be addressed, and that's a whole probably separate day conversation. And then there's this regulatory framework that's in place that I believe unfairly puts the burden on the participant, and it doesn't put any shared responsibility to the broader group. And so I'll go into that in just a second, but you know, I want to leave everyone with a thought. You can agree with me or not disagree with me, but what I hope is that we could agree on one fundamental principle. And that principle is no one should ever be at risk of losing their entire economic livelihood by no fault of their own. And that is something that is happening, and it will continue to happen until change occurs. You know, and I'll get into why I support that position. But, I was asked to come and share my experience. And, what I'd like to be able to start with is that back in July, and again, I know the rules have changed. At last July, my trainer received a notification from a HILU investigator at 7:40 in the morning on a Saturday morning of the 4th of July weekend that he received a positive for the drug known as metformin. We had 18 hours to disperse 151 horses because he was immediately suspended. And we talk about, the healthcare and the wellness of the animal, but under no circumstance was that a brilliant idea to say that you would have 18 hours to disperse 151 horses. So we did it. We did the needful. I didn't own the horse that was in question. My affiliation with this entire situation only is to the extent that I care about I call my trainers my employees. I care about all my employees. And I don't care, which one of my trainers it is. I would defend all of them because if they look me in the eyes and they tell me that they didn't do something, and in this case, in particular, before I decided to take this on, I also had my trainer polygraphed because I wanted to make sure before I stuck my neck on the line that I knew what I was walking into, and I believed what he had to say, and that was that he didn't do anything. And so when I know the set of facts and circumstances, it was a cause that I was willing to get involved in to try to get resolved. And I have no experience in the litigation of the HISA framework. I didn't know what to expect going in. I'm a business guy. As I said, I own a technology services company. I really felt like early on that this would be a situation just like any situation. It's not, I've had vast experience in the federal circuit court with various different things that, business ventures, protecting our rights and interests. And so I really felt like if we went in, we explained our set of facts and circumstances, there would be an amicable solution or resolution at the end. I underestimated that position. That is not how this process works. What I've come to realize, and the factual basis is, it doesn't matter what any of these trainers do or don't do. If they get an adverse analytical finding, the burden on them is, if they didn't do it, the burden as it exists today is to prove source. Unless you can prove source, nothing else matters. And that's a fundamental challenge with that thought process, and even that, or the adjudication of that, because you have to think about it in the real practical situation, which is you receive a notice roughly 30 days after the fact. So you don't have the ability to go and investigate to discover what happened because it was 30 days ago. And in our instance, ours was a ship-in scenario. So the trainer wasn't there, the groom wasn't there, none of our employees were there. This animal got on a van at 4 a.m. in the morning, shipped to the racetrack in question, went to the receiving barn, ran the race, won the race, went to the test barn, got back on a van, and was shipped back to where the horse is stationed. So 30 days later, when you don't have the ability to subpoena anything, you don't have the ability to do a discovery, you don't have the ability to do depositions, you don't have the ability to gain videotape or anything to see who may or may not came in contact with the animal, it puts you in a very disproportionate position. And so trying to prove source is incredibly difficult. And to this day, we do not know where the source of the contact came into play. So as I said before, when I set up the legal team to fight this, I did what I would do in any situation where I'm not comfortable or familiar. I hired what I believe to be the best attorneys available. I hired the best experts available. So we walked into our arbitration with 4 attorneys and 3 experts. And unfortunately, what I found is that when you challenge this entity, they don't like it when you challenge them. And they seem to take offense to the fact that you challenge them. And what I also should mention is that I think everyone's aware that Metformin is a drug that has subsequently been changed twice on how they are treating and managing the adjudication of this medication. Originally, during our, prior to our arbitration and leading up to it, they introduced this lab harmonization concept, which was, hey, which bluntly was, they publicly said that there's this harmonization effort, but really what it meant was their labs couldn't detect the same substances at the same level. Even despite what they had said publicly about, for the first time ever, they have the ability for all of their labs to detect the same substance at the same level, said it on national television, all the media that would publish it. But the fact of the matter, that's patently false. They can't. We've since learned that through our process or under deposition, or actually through the arbitration, so people testifying under oath, that they don't have that capability. So that's where this harmonization effort came in, which at the end of the day, what that harmonization determined was establishing some thresholds. And so some people that had tested for this metformin drug at that point in time saw their case resolved, others did not. I can't go into what the harmonization levels are, but what I can tell you is that they don't make any scientific sense. What we also uncovered during this process, and this is really, really important, is that the treatment of this particular medication, and it raises a broader question, but I'll focus on this particular drug first. Their determination of the classification of this medication was not based on science. It was based on, as they put it in their direct quote, they had received whistleblower complaints that trainers were using it to try and enhance performance. So when I think about that for a second, I'm saying that you are making a medical classification not on science, but on third-party unsubstantiated hearsay. And that is fundamentally challenging for me, because we should be driving and doing all of this based on science. And we also should be doing it based on what I believe to be, at the time, the purpose of this national regulatory body, which was go after those that are affecting the outcome of a race. That's what I understood this to be. I also understood this to be that they were going to have uniformity, national rules, so that if you knew you were racing in one state versus a different state, you knew what the rules were, they were equally applied, so you had a common understanding of what to expect and how to be able to participate. And I absolutely support that. And I absolutely will say that is what is needed. And I will absolutely say that, and I've said this publicly, I absolutely support a regulatory framework that goes after those that put their own self-interests above those of the animal or the other participants. That's what I think we should be doing. The problem I have is that, with this case and with many of the other cases that I have, been exposed to, because a lot of folks have reached out to me and shared their stories, a vast majority of these situations in these cases, the threshold or the testing that they are determining, meaning what is the concentration levels, are well below any pharmacological effect that would affect the outcome of a race. And that's very prevalent in my case. I mean, in my case, I won't get into the specifics, people can read it, but because it's been published, I have 3 worldwide one of them's a Nobel laureate that have testified that the level present is so far below a pharmacological effect. And in fact, they took it a step further to say that the level in the urine was because there's a differential between what's in the blood versus in the urine, and the urine concentration is higher. And what it leads to is that, and their statement was, and this is like I said, a world-renowned Nobel laureate, the only plausible explanation is that the animal came in contact with the substance at or around sample collection time. And so what that means is that it's an environmental contamination conversation. And I want to bring this up because we brought up the notion and theory of or my concern about, this ship-in scenario about environmental contaminations. And we brought that up last July. I was dismissed and discounted and quite frankly, went after by folks in the media as well as the Jockey Club, that for challenging all of this, but even raising the notion that, this environmental contamination. And because according to them at the time, environmental contaminations couldn't occur because all of their folks had been certified. And certified in what? I have no idea. That actually has never been explained, but they've been certified. But what I also have learned since then, and it isn't public yet, but it will be shortly, there are more cases of ship-in positives, irrespective of the drug, whether it's prohibited or banned, but there are more positives from ship-in scenarios than there are from horses running out of their stall. So that's a fundamental problem. What it says is that we have the ability to detect substances at such a de minimis level, but what it says is that we don't have a sterile environment that is preventing these animals from picking it up. And that is a challenge because one of the things that, this racetrack safety initiative is what I understood to cover is the receiving barn and test barn, but it doesn't. And when we asked HIWU, what are they doing to investigate these situations? The response was, well, it's not their job to investigate, and it's our job. But how can I investigate when everything's after the fact? And so, my concerns are, as I said before, when you have a scenario where somebody can ship into a race, irrespective of who, because I will say we can agree on who we think is doing things, who may not be doing things. Put all that aside. Think of it as a blank piece of paper, no names, and just look at scenarios. And if you have a situation and scenario where people are shipping from point A to point B to run a race, fill a race, work with a racing secretary to make a race go, and which is good for the game. If you have that and you're finding out that, your animal at some point in time or you gets into contact with something and generates an adverse analytical finding, there's nothing you can do. I mean, you have to then try to figure out improved source. And so a lot's been made of our situation where our story's changed and this, that, and the other thing. And what I want to address that because our story hasn't changed. We've brought up all the fundamental concerns that we've had from the beginning. They just wouldn't entertain them, because you also have to understand, we have demonstrated, and I have an administrative law judge with the FTC who has already ruled that HIWU has no chain of custody as it relates to our samples. So they can't actually say that the blood and urine drawn from this animal actually relate to the animal. And their rules, unfortunately, say that they don't have to. They don't have to actually be able to demonstrate and prove it. They have a rule that says they're supposed to, but if they don't follow it, that's okay because the assumption is that the intent is there for it to ensure that they're covered. What their rules also say, and we've demonstrated this through some lab failure and lab defects, is that their lab failure and performance, their lab's ability to execute and perform against not only their rules as well as the lab accreditation standards is not a plausible defense. Because, what they will say is that unless you can prove how the lab failure led to the adverse analytical finding, you're still guilty. Well, my point is that that's kind of the definition of an error. You don't really know. And one of the things I would also say is that we had the water tested at the racetracking facility as well as the training center that the animal's at. And in all 5 tests, the metformin was present in the water table at all 5 locations. Now, before anybody gets too excited on that one, my experts also, explained to me that the level that would have to be ingested was substantial. So that wasn't really a plausible defense for us. But my point is, when you think about how all of this particular medication is being adjudicated today, the pausing of prosecution until they investigate, discover through the RMTC, and, you know, they may or may not, make a change on how they treat it going forward. But my point is that if you made a medical classification, not based on science, but based on unsubstantiated hearsay that has destroyed the economic livelihood of an individual and several individuals that have fallen afoul of the same medication by no fault of their own, that can't stand, because you cannot take somebody's livelihood from them by no fault of their own. And, one of the other things I would say is that during this entire process, when we were challenging that, when they don't have the chain of custody, people need to understand, we requested DNA twice on 2 different occasions, and we were denied our ability to have DNA testing because we kept arguing that, since you can't prove it relates to this animal, we would like confirmation that actually the samples relate to this animal. And when I say that failure of the lab work product, I had the lab director under oath testifying that they lost the samples. So, when I sit here and look at this around what is happening, when you lose samples, you don't have a chain of custody. Again, I don't believe that it's an intentional act, but I do believe is that there are unknown scenarios in this equation that are very mitigating, that don't warrant the suspension and the fines that have been generated. And, quite frankly, in hindsight, if I knew what I knew, know today, back when all this started, I probably would have just paid Jonathan to sit on the sideline for the 18 months they're originally offering, and I would have saved hundreds of thousands of dollars. Because that's the last thing I want people to understand, is I have personally spent over $620,000 litigating this to date with no end in sight. And that's the unfortunate reality of this situation, is that I've got a situation where, by no fault of the individual, we're continuing to fight this. We're waiting for the FTC to make a final ruling on whether they're going to allow us to take our case before the 5-panel review. But I'm doubtful that they're going to do anything. And I think that with the Fifth Circuit ruling, what it's, has just recently ruled, I don't see the FTC doing anything anytime soon. So, and the way these rules are written, you have to go through this process. You can't just automatically go into federal district court and file a claim, because what will end up happening is, if you do that, the district court can look at you and say, you haven't exhausted all of your administrative rights and remedy, so you need to wait until that happens, and then you can come in and make your claim. But the problem with all this is you don't know if or when they're going to even do that. So you could be sitting here in limbo for an extended period of time. And so Jonathan, in this case, he's already been suspended a year. He's already a year into his suspension. And I also want to highlight that when HILU made the decision that, they were going to look at this medication and do further analysis and make a determination on how it should be treated going forward, we asked them to stay his suspension pending that outcome, and they said no. And then when the Fifth Circuit ruled, we asked them once again to stay a suspension until a legal decision can be made on what's going to happen, and they said no again. And so, if anyone thinks that this is fair and reasonable, I would disagree. I know that others that have gone through this process have received a better, more favorable outcome. I don't know why, our situation's different, other than I continue to be an advocate for what I believe, or for all the people that are going to come behind, our situation, because I think when you're the first, we're the first to go as far as we have. When you're the first, I think they want to make an example out of us. I know personally, they've tried to make it punitive to me. For those that don't know, I have personally been ruled ineligible to participate in the HISA database twice, both through what they called administrative errors, blaming the racetracks and the stewards, one of which was one of my horses, the jockey had used his whip one too many times, and so the purse was forfeited. And so I was ruled, as the owner, I was ruled ineligible because they said I hadn't repaid the purse. But the problem was the purse was never paid to me to begin with. And so the material consequence to me as the individual, I didn't know that I was suspended in the HISA database. So when my trainers went to enter my horses, I was prohibited from entering, and horses that were entered were scratched. I have to thank the stewards in the state of Kentucky and the state of California, because they went to bat on my behalf and said, this is absolutely ridiculous. Mr. Malmstrom had done nothing wrong. The money was never paid to him. So it was again, administrative error. A second time around, they reported one of my horses as being deceased. When he wasn't deceased, he was standing in a stall and he was prohibited from racing. So we had to work through that issue. But again, whether these are unintentional acts or purposeful acts, I'm not going to speak to. I'll just tell you that they don't like it when you stand up for yourself and fight back. So with that, I'll conclude my remarks to just to reiterate that we can agree on a lot, and I think we can disagree on a lot. The one thing I'm hopeful that we would all agree on is just this simple notion that no one should ever be subjected to losing their economic livelihood by no fault of their own. Thank you for your time.
Thank you, Brett. Will you be able to stay around for the question and answer period?
Yes, sir.
Okay, great. So we'll wait till the end then and allow people to come back and ask you some questions. I'm sure they have a bunch. We'll then turn it over to Daniel for his presentation.
Yeah, good morning, everybody. I guess let me just start by saying thank you. That, 3 years ago when I first came to this fight, I will admit to you, I knew nothing about horse racing. I was reading a HISA rule and I had to learn all about toe cleats, and then I had to turn around and explain it to a federal judge. But you guys have just been so gracious in taking this nerdy constitutional lawyer into your midst. I still remember the night before our first oral argument in New Orleans. We were going to go out. The New Orleans guys were hosting us for dinner beforehand, Eric, Peter, and I. And we were going to go out. And I showed up in my Ryder Cup golf polo and was treated to a night of oysters, bourbon, and SEC football. None of which are my thing. I'm a nerdy constitutional lawyer from Milwaukee. It was a totally new experience, and I only had one bourbon because I had to argue the next morning, making me the only one at the table to only have one bourbon. But I just kind of so appreciate how over the course of 3 years, you all have accepted me into your little fraternity and trusted me. I think I realized two things from your perspective. One, this is not anybody's idea of fun other than me and maybe Pete and Peter. But being in the middle of a big constitutional law fight is not your idea of fun. You want to do horses, you want to be with your animals, you want to be at the racetrack with your friends. Listening to 3 lawyers talk about the meaning of the private non-delegation doctrine is not your idea of fun, and I get it. The second thing I think I get is that this has been a really long fight, and it's only going to take longer. It's not over yet. And I know it is hard when you're trying to do your business, live your lives, care for your horses, and in the midst of all of that, you're like, what states does the Fifth Circuit cover? And what states does the Sixth Circuit cover? They did not cover this in law school, a little less in horse racing school, right? And I get that it has been a really long fight. And I am just grateful that you have been faithful with us in sticking it through. Because ultimately, I believe what we're fighting for is really important. And I think it's important for this industry, and I think it's important for this country. That's fundamentally what I'm here for, right? Why is the nerdy constitutional lawyer here in the first place? It's because I think this is important not just for this industry, although it is obviously, you guys live it every day, but I really genuinely believe it's important for this country that when we talk about protecting horsemen's rights, when Eric uses that phrase, It's really about protecting Americans' rights, right? It's about our relationship with our government and what it looks like in a free society to be self-governing. It's about fundamental principles we all believe in around democratic control, right? Like our elected officials are the ones who actually make our laws. I know that sounds crazy. That assumes that Congress could actually pass a law, but at least in theory, like that's the way it should be. And transparency and accountability, these sort of fundamental American values are the things that we're really fighting over. And to some extent, this HISA fight is just a vehicle for these broader principles that ultimately I think are what the Supreme Court's going to deal with. So what Peter asked me to talk about is just to do a little bit of a victory lap because good news, we won again. Was like we won the first time, and then they fixed it in the middle of the night, and so now we're back. And again, I appreciate your patience. The last time we were all in New Orleans, we were there in September, and I was like, oh, like we'll get a decision by January 1st. Like it's a really interesting issue. They know the case inside out. We'll get a decision by January 1st. And no, it was on July 5th. So I didn't even know there were federal government employees working on July 5th. But I'm sitting in a hotel room with my family on our 4th of July vacation when Peter texts me, and I'm expecting some like fireworks emoji, right? Because that's usually what I get from Peter is some sort of, happy message about the day or some interesting news story. No, it's like the case is decided. Like, I need you to answer your phone, Daniel. Okay. Thankfully, we had a press release ready to go, but 5 p.m. on a Friday, who knew government employees work then on a holiday weekend? We get this opinion from the Fifth Circuit, and that we've been waiting for months at that point. And the good news is, I think it gives us most of what we want. I'll be honest, it didn't give us all of what we wanted. The first question that we asked the court is, did the fix that Congress passed fix it? And one of the ironies of this case is that when we were answering that question of did the fix it, our view was that the language of the fix sort of gave the FTC a very narrow authority. And their view on the other side was, oh yeah, the FTC has all this brand new authority and they can do all of these things. I have yet to see any evidence that that is actually the attitude they're adopting, right? That the FTC actually intends to use all of this authority that they think they have, but okay, we'll set that aside. So the court starts by saying, well, the fix fixed it. And the first time around, they only asked this question about who writes the rules. And they said, well, the way they write the rules is unconstitutional. So we're just going to stop there because it doesn't matter about enforcement. It doesn't matter about anything else because we don't need to get to those questions because the way they write the rules is unconstitutional. Second time around, they say, well, the way they write the rules now is constitutional. So now we can reach the second question about the way they enforce the rules. And I just want to read to you a I realize again, your idea of fun is not listening to legal opinions, but bear with me, I think it's important. What they ultimately come down to is this question of the power to launch an investigation, to search for evidence, what Brent has been living through with Jonathan, to sanction, to sue. Like these are core governmental powers. And the court doesn't use the phrase, but the phrase that I've been using all along is essentially what the act does is it creates a private police department that then sends cases to a private district attorney's office that then hauls you in front of a private kangaroo court. Like that's the way this thing works. I keep waiting for one of you to tell me that a HISA investigator showed up and like actually flashed a badge because I think that's the attitude of the authority. And so here's this first of two paragraphs I want to read out of the opinion. The Act's plain terms permit only one conclusion. HISA is enforced by a private entity, the authority. The authority decides whether to investigate. The authority decides whether to subpoena an entity or search its premises. The authority decides whether to sanction it. The authority decides whether to sue the entity or enforce a sanction. And it goes on. Put differently, the FTC does not decide whether to investigate. whether to subpoena, whether to search, whether to charge, whether to sanction, whether to sue. Nor does the act empower the FTC to countermand any of those decisions. Nor does the act require the authority or HIWU to seek the FTC's approval before investigating, searching, charging, sanctioning, or suing. I actually think this is one of the great ironies. Think about it this way. If you were just running your private business and the FTC thought that a bunch of horse owners were getting in a antitrust conspiracy, right? That you were fixing the outcomes of races, but in some other industry. If the FTC wanted to show up at your office and search your office and take your laptops, they would have to fill out a search warrant. They would have to have probable cause that a crime was being committed. And then they would have to go to a neutral federal magistrate judge to get permission to search your premise. If the authority wants to show up at your barn and seize your laptop, they don't even have to check with the FTC, little less checking with an independent neutral federal judge, right? Like the authority doesn't even operate under the same rules the FTC has to operate under. And I think it all comes back to what Eric said at the beginning, that this is really about protecting horsemen, that this is about protecting you guys because you're the ones who are the victims of it. It's people like Jonathan and Brent who are the victims of it. And the judges actually get that. So this is something we didn't put in any of the briefs, that the judge went out and found on his own. And you can tell from the opinion he's pissed about. Not only does HISA facially permit these investigatory schemes, it's already happening. In one current active and undecided FTC case, 3 private authority investigators showed up at the horseman's residence, served a notice of alleged doping violation, subjected her to a coercive interrogation in a small room, searched her barn and her mother's car for banned substances. She was then fined $55,000 and banned from racing for 48 months under the authority's strict liability scheme. In another instance, a veterinarian forgot to clean out his trailer and had 2 buckets of a newly banned substance 2 weeks after the effective date. Private authority investigators searched his trailer, found the buckets, fined him $5,000, and banned him from practice for 14 months. The FTC affirmed this on appeal. All of this, despite the fact that the authority and the ALJ conceded the appellant purchased the substance before it was banned, forgot it was in his trailer, and never even attempted to use it on a horse. That's just straight out of the opinion, right? I mean, I think you can probably hear just how annoyed the judges are at just how outraged they are at the factual circumstances. And I think it goes to this underlying point that it's not about this like private non-delegation doctrine. Yes, that's the phrase that lawyers like me are going to use. It's about what Eric said. It's about protecting horsemen's rights because you couldn't do that in any other circumstance, right? Like if you guys just watch enough cop TV shows, you know that there are certain basic things you have to do. You have to read people their Miranda rights. You have to let people call their lawyer and ask if they want to come before you ask them questions. You have to prove your chain of custody for your evidence, right? These people have to do none of that. And so it's not just that they're violating this one constitutional principle that we can't let private organizations use government power. It's that through that one violation, they're violating like 10 constitutional principles, right? The 4th Amendment, the 5th Amendment, the 6th Amendment, the 7th Amendment, go through the Bill of Rights. They're violating all of them at once because they're doing it through this private organization. So the opinion, I think, is really good. It's a great opinion. The one other argument that it dispatches really strongly is this idea that this is like the SEC and the Financial Industry Regulatory Authority. Again, I know this is none of your idea of fun, and I think probably when you were all going into horse racing, you never thought there was a day you were going to learn all about the horse racing industry as a cognate to the securities and trading industry, right? But like now we're all reading some law professor in TDN talking about the analogy between HISA and FINRA. So here we are. But what the court says is, sure, maybe the rulemaking now looks like FINRA. Maybe they fixed that problem. I don't think they did, but will say that they did. It is a radical departure. That's the court. That's not my phrase. That's the court's phrase. It is a radical departure between HISA and SEC FINRA when it comes to all of the enforcement and oversight. There is no one sentence fix. Last time around, they literally added one sentence to the law. We're talking about pages of paragraphs of fixes if they wanted to try to make it like SEC FINRA. It's just not there. It's just too different. It is a radical departure. So I'm really happy with the opinion. Judge Duncan gave us everything we need to go on and move forward in a great position. So I know the frustration is, okay, we won. Now what, right? Like, don't we get the fruits of our victory, Daniel? And the very practical problem is that the winners do not get to appeal. The losers get to appeal, right? It's not our position to be in the driver's seat on what happens next because we won. So the good news is we won. The bad news is they're in the driver's seat on what happens next because they're the ones who get to appeal. And they have several different options on how to appeal. And the law gives them 45 days to figure out which of those options they're going to take. So I know it is annoying, even frustrating to kind of be like, we won. Great, now what? And the answer is, well, we won, but we got to wait 45 days. And at the end of that 45 days, then we get to argue about now what. So I get it. I know it's frustrating. It is what it is. The ball is in their court. I can't tell you exactly what they're going to do, but I can tell you this much. We're going to have two sort of questions in the next phase. The first question I think is really easy to answer, and that is, will the Supreme Court hear our case? And I think the answer is almost certainly yes. When the Supreme Court decides what kind of cases it's going to take, there are three questions that it asks. Number one, do the lower courts disagree with each other about this topic, right? If the Fifth Circuit says one thing and the Sixth Circuit says something else, or the Eighth Circuit says something else, well, then we as the Supreme Court need to step in and resolve this conflict between the lower courts. We got that, right? Judge Duncan says it straightforwardly. We like the Sixth Circuit. We respect them as judges. We think they got this one wrong. So, boom, box checked. Second question the Supreme Court asks is an act of Congress being interfered with, being struck down by a court, right? Because like we as the Supreme Court respect Congress, we owe them some deference, some respect. And if one of their laws is declared unconstitutional, like that's a big deal and we should look at it. So that's another box that we check. And then finally, we know from a case 2 years ago, Supreme Court justices are nerds like me. And so they drop little hints and footnotes along the way about things that they just find intellectually interesting. And one of the things we know from 2 years ago is that 3 of the justices have said, we find this question about private organizations exercising government power really interesting. And we would love a case in the future that lets us deal with it. So any one of those 3 things would be a really good indicator that the Supreme Court's going to take your case. Having all 3 of those things at the same time is nearly unheard of in my business. Like you're checking all the boxes. So I feel really good about the Supreme Court deciding to hear the case. The second question then is, okay, how long is that going to take and what's going to happen in the interim? June of every year for me is like March Madness, right? It's the most wonderful time of the year for Supreme Court nerds. I don't know if it will be June of 2025 or June of 2026. Again, that's a little bit on me and a little bit on the other side. I think that they might move quickly, right? They want this to be over and done with. We're finally getting to the Supreme Court. That's where we've wanted to be all along. That's where they've wanted to be all along. And so they may move promptly, and we may get a decision by June of 2025, right? We'll get our papers in this summer. They'll take the case. We'll brief the case. I'll fly to Washington, D.C. in January. I will have no bourbon the night before that particular argument. Eric and Peter may, and I will have several after that oral argument, but none the night before. And, you know, maybe we'll get it done January, February, have it argued, and get a decision by June of 25. I think that is possible. I think it is at least equally possible that the other side will drag their feet, right? Every time that they get 90 days under the rules, on day 89, they're going to send a letter to the court asking for a 30-day extension, right? Which they're going to get. And they're going to drag their feet and they're going to try to push it out because they know the longer that this is in place, the longer that they get to, it's like a tick burrowing in, right? It's the harder and harder it's going to be to pull out. That's the way they think about it. I have a 10-year-old who just came back from Boy Scout camp. So ticks is where my brain is at this week. Right? That they're going to try to burrow in longer. And so if they can stretch it out for another year and a half, that may be their strategy. It won't surprise you to know, like Pratik, the lawyer on the other side, does not call me and tell me these things. So I'm just as in the dark as you guys about what strategy they're going to take. In the interim, between now and June of 25 or June of 26, I'm going to do my best to get you guys as much relief as I can, as fast as I can. What that's going to look like, I can't exactly tell you. There are reasons to hope that we might get just relief in Texas, Louisiana, because that's where the Fifth Circuit is, right? And maybe Texas can start exporting its signal again, which if you're from Texas is obviously a big deal. It's a lot of money on the table. We might get relief for all the state affiliates that are participating. We might get relief for a lot of the country. I just don't know. This is always sort of an awkward dance where on the one hand, the judges want to give us the fruits of our victory, right? Like they're obviously offended by what's happening here and they want to stop it. On the other hand, they recognize that the judges in, say, the Sixth Circuit came to a different conclusion. The judges in the Eighth Circuit haven't decided yet, and they're going to want to respect their colleague judges and their zone of authority. And so I just can't tell you today how it's going to go. All I can promise you is I'm going to fight really hard to get as much relief as possible as soon as possible. And to the extent that there are any 90-day deadlines that come up, we are going to be filing on like day 45, right? Like I'm going to push to get this thing done as much as we can, as fast as we can, to get you guys as much relief as we can, as soon as we can. I'll end on, and I don't want to steal Peter's thunder because I know he's going to address it next. All of that is just leading up to the big show, right? My version of the Kentucky Derby is a Supreme Court oral argument, right? Like that's the big dance for me. And I think that's where we're going to end up. And I am really hopeful when we get there. And I am hopeful because like I can just do math, right? Like I got to count to 5. And looking at the Supreme Court over the course of the last year for certain, but really looking at the course of the Supreme Court over the last 5 years, I'm going to say, like there has been a consistent pattern where 6 of the justices are deeply skeptical of what I'll call the modern administrative state. The blob, the swamp, call it what you want. It's not about your politics, right? Like it's just this reality that things keep growing and growing and growing. Sometimes I joke that the Constitution, like any of you who did like 4th grade civics, right? Like we have 3 branches of government. And now law professors talk about the 4th branch of these independent regulatory agencies. The one thing I can tell you is there's definitely no 5th branch of private nonprofit independent regulatory agencies. Like that just ain't in there anywhere. And they get that. They really genuinely get that. And Peter's going to talk in a minute about several of the cases we had just this term that I think reflect that. But I actually don't want to give up on getting to all 9 justices. I think 6 justices look at the world, see the swamp growing and expanding and metastasizing, and says, our job is to put the swamp back in the box. There are 3 other justices, though, who come from a different ideological basis, and they are really concerned about the rights of criminal defendants, right? They look at the world and they see Black Lives Matter and police departments run amok and all those sorts of things. and they are really concerned about the rights of criminal defendants. And so I'm actually somewhat okay with the fact that we're going to have this fight not about rulemaking, but rule enforcement, because I think it actually gives us a better shot at convincing them to come around, because I think they are going to be just as offended as Judge Duncan was at the idea that we're going to have people running around roughshod over people's Bill of Rights. So I'm not giving up on anybody. I'm going for 9-0. I'm not going to promise you we're going to get there, but we're going to shoot for it. Yes. Okay.
Lynn McNally,
Hey,
Nebraska HBPA. Thank you so much for your efforts. We deeply appreciate what you've done for us.
Thanks for saying so.
Is there a scenario in which the plaintiffs in the 6 drag their feet so much that it never gets heard? Is that possible? That it doesn't get to the Supreme Court?
I don't think so.
Okay.
So I two reasons why. One, it would be, I would say, extraordinary. It's not that it's never happened before, but it has, virtually never happened before, that the United States Department of Justice has not appealed to the Supreme Court when an act of Congress has been shut down. And frankly, the only times it happens are on really politically charged decisions, right? So, and I know in our world, this is like supercharged, but in out their world, like this is not, surgery on transgender kids, right? Something that's super politically charged. Like there have been those very unique instances where the Department of Justice has decided to just take a loss in one specific little geography and not appeal. This is not one of those cases. So first reason, it would be extraordinary for them not to appeal. Second, we have some appeal rights too, right? We made 2 arguments: that the legislative rulemaking was unconstitutional and that the rule enforcement was unconstitutional. We lost on the first issue, we won on the second issue this time. We always have the option to appeal on the first issue.
Okay.
And so if they don't move, like I expect they will move, I will try to kick them in the pants to do it by exercising our appeal rights too.
In light of the Chevron doctrine being overturned,
Yeah,
I just think we have a tremendous chance of them ruling in our favor. I mean, I think that was a very clear indicator of which way they're going to go.
I mean, amen, sister, right? So those of you who may have seen in the news this last couple months, the Supreme Court had a major case on administrative law this year. We use the name Chevron because that was the case from years ago about whether or not judges had to defer to administrative agencies. And you guys actually can very much sympathize with the circumstance. It was about fishermen rather than horsemen. And the particular rule, which is going to strike you as crazy, but bear with me, was that the federal government was going to put a monitor on your boat every day you went out to go commercial fishing. And you were going to pay for the monitor to be on your boat as part of your licensing fee. And then that monitor was going to count your fish, basically, on behalf of the government. And you were going to pay for the privilege of having this monitor camped out on your boat. And it was nowhere in the rule, it was nowhere in the law. The agency just decided to do it. And it goes up to the Supreme Court in this Chevron case. And after oral argument, there were a bunch of nerdy law professors. And I'm just going to remind you here, don't believe everything you read from law professors in TDN or anywhere else, right? There are a bunch of law professors who listened to the oral argument and said, oh, they're gonna cut back on Chevron. They're gonna try to put Chevron back in the box. They're gonna try to limit Chevron. No, we got the opinion. They just overruled it. I mean, it was just gone, kaboom. They went whole hog, 110%. And so if that was their attitude in that case, one of the ways when I talk to news reporters is I've been saying, I think horsemen are going to be next year's version of the fishermen. Just like those fishermen were, on NBC's Today Show telling their story about being the victims of big government. I think horsemen are going to be next year's version of that, where when we talk about big constitutional cases and we talk about, what's in the news, it's going to be our case. And I think you guys are an incredibly sympathetic audience. I mean, people like Brent and Jonathan, for what's happening. And like, people are not going to put up with it, and judges aren't going to put up with it.
Thank you.
Yeah. Thanks, Lynn.
Thank you, Daniel. And Judge, we've got a question and answer at the end, but Pete's going to cover your Eighth Circuit case, so you might have questions for him. We're going to have time at the end after Pete's done for question and answers. But I want to get Pete in here because he's going to get blocked out if we don't.
I'll get you, Judge. Don't worry.
Yeah. Okay. Go ahead, Pete.
Pass that one down there. Well, thank you. And it's certainly a great opportunity to be here today. And thank you for this opportunity. Again, my name is Pete Sikopoulos. I'm a practicing attorney in Indiana. I'm licensed in Indiana, Illinois. And over the past 25 years or so, I've represented horsemen in many jurisdictions across the country and have consulted on a number of HISA and HIWU cases since the federal rules have become effective. My involvement really has been almost since the inception. When the HBPA filed its first suit in the Fifth Circuit, the first case that was argued was in the division in Lubbock, Texas. And the HBPA argued, and I was there. I argued on behalf of NARB, and the quarter horse folks also argued. So since that time, I have written 4 amicus briefs, one to the trial court in Lubbock, Texas, one to the Fifth Circuit Court of Appeals in New Orleans, and 2 to the U.S. Supreme Court in connection with the Sixth Circuit case. So I've kind of been in the fight since the beginning. I think one of the things that we talk about when we're talking about HISA and the constitutional challenges to it that I thought might be helpful before I go to the Eighth Circuit is, what are these challenges? Because sometimes we talk about non-delegation doctrine, and we go to anti-commandeering, but there are more, but there are 6 primary challenges to the HISA legislation. The first is the non-delegation doctrine that basically stands for the position that it is the legislature that is making the laws and that it cannot delegate that to a private entity like it is done to the authority in the case that we're discussing now. The second is a due process argument. The due process argument basically states that it prohibits one group of economically self-interested private actors from trying to govern or exercise authority over another. And so in this case, we have a private actor trying to exercise authority over other private entities and actors within our industry. The third is the appointment clause. The appointment clause stands for the proposition that it is the executive branch of our government that appoints those that are running the agencies. And that in this regard, with regard to HISA and HIWU, what we really have is a quasi-governmental agency that is self-appointing. They have a nominating committee, which is self-selected. They have an authority, which is self-appointed. That there is no executive branch appointing anybody in this. It's basically a private club where they're self-appointing and self-selecting each other. So it runs afoul of that. The fourth is the anti-commandeering argument. And that is the one that was advanced quite forcefully by Texas in the Fifth Circuit case. You remember with regard to the state of Texas, the argument is that we cannot buy into this HISA HIWU scheme. And the reason is that the Texas Constitution provides for an agency within the state to govern and conduct horse racing, and that's the Texas Horse Racing Commission. So that we cannot agree to this because it would be in violation of our own Constitution. Now, the anti-commandeering provision states that the federal government cannot come in and take over state regulatory authority, which is exactly what it was doing in Texas, exactly what it's been doing in all of our jurisdictions. So in addition to these 4 arguments, the non-delegation doctrine, the due process argument, the anti-commandeering, and the appointment clause, we have 2 additional challenges that we see in these cases in the Fifth Circuit, the Sixth Circuit, the Eighth Circuit, and what was formerly the challenge in the 10th Circuit. And those are 2 constitutional challenges by way of amendment. The first is the Seventh Amendment argument. The Seventh Amendment of our Constitution reserves the right for somebody who has been charged with a violation or alleged to have had a violation to have the right to a trial by jury if there's a monetary penalty. And all of us in this room know that if you are subject to an allegation that you have violated a rule, there are really kind of three parts to what can happen to you. You can be forced to surrender the purse. You can be ruled to be ineligible to participate in racing for a period of time, a number of days, and then you can be assessed a monetary penalty. Those would be the three forms of the penalty. So if there is a monetary portion to this, a monetary penalty, the argument under the Seventh Amendment is, then we want a right to have our case tried to a jury and not to a self-selected arbitrator. The Fourth Amendment is one that Daniel has spoken to. It deals with search and seizure. And so the Fourth Amendment is that you have gotten far afield from what our rights are under the Constitution with regard to searches and seizures. He went through with you the idea of the getting a warrant, having probable cause. In the case of HIWU and HISA, they simply just write up a warrant and out they go and they start searching and seizing things. Now, the viability of each of these arguments has been put forward in these different cases. You see them in the Fifth Circuit and the Sixth Circuit. The Fifth and Sixth Circuit are the ones that have gotten the most attention because we have had this divergence in opinion. The Fifth Circuit originally, when it was argued in Lubbock, found the HISA to be constitutional. It was only on appeal the first time that it was found to be unconstitutional as to the writing of the rules, to creating of the rules, to basically legislating these rules. So, but now it's shifted elsewhere. One of the cases that happened in this last term of the U.S. Supreme Court involved a gentleman named Mr. Jarkessi. Mr. Jarkessi had got into a rub with the SEC, and his case went through the administrative process, and he said, well, you're seeking a large penalty against me. If you're doing that, I want to have the right to be heard by a jury. And the SEC said, too bad. And Mr. Jarkessi said, well, then I'm going to appeal. And the decision came down that you are entitled to a jury trial. I would tell you that this presents a very interesting situation for those people who have a run-in with HIWU or HISA. The question now is, do you have to really go through the administrative process that they've created? Their regulatory rules, their adjudication rules, their penalty rules, or do you have the right under the Seventh Amendment to remove the matter from HISA and HIWU and go directly to a U.S. federal district court? And I think under the Jarkessi decision, you now have authority out of the Fifth Circuit that you do, and you have further authority from the U.S. Supreme Court, which has made that ruling that you do. So what does that mean? Well, it means a number of things, and I think one thing it means to me, who I have represented horsemen for years, and one of the problems that we always have in representing them is the cost involved. You heard that in the first presentation. To work your way through this administrative labyrinth is an expensive, long process. There's better part of over $500,000 having been spent, and I think the term was with no end in sight. If you were to file the matter in federal court or remove the matter to federal court, you have a number of different advantages. One is you have the federal rules of evidence. When you are proceeding before HIWU or HISA, it is unclear. A couple of the cases I've consulted with, one of them used the Court of Arbitration and Sport rules. If you look at HISA, it references the federal rules of evidence, which would make perfect sense because at the end of the administrative process in HISA, your appeal, instead of going to a trial court like all of us are used to under the state regulatory system, you go to not a federal trial court, but you go to a federal court of appeals. And I believe it's been stated in the past to all of you, that's an expensive ticket. Now, on average, $25,000 to $35,000 to go to the federal court of appeals. And that may be light. But if you can remove it directly to federal court, you have a number of advantages. One is you have the federal rules of evidence. So this Court of Arbitration and Sport business with expert witnesses and exclusion of evidence is not going to be nearly the problem. The second is you're going to have a case management order that will move things along but allow for discovery. this idea of not having interrogatories, this idea of not being able to get documents that are necessary to defend the case is in and of itself a serious due process consideration. You would not have that in federal court. The other thing you have in federal court is you'd have a federal judge that would be assigned to the case. You would also have a federal magistrate that would be assigned to the case. And most of those magistrate judges in most jurisdictions are tasked with getting both parties together, getting them close, and banging their heads together until the case is resolved. So you have an independent person that is tasked with trying to get some resolution. And of course, the resolution by the independent party would presumably have some degree of fairness to it. That seems to, so far in the cases I've been involved in and observed, to be somewhat lacking in the HISA administrative process. So to summarize here, we have 6 primary challenges to HISA. We have the non-delegation doctrine, the due process argument, the appointment clause, the anti-commandeering argument, the 7th Amendment argument where you have a right to trial by jury, and the 4th Amendment argument that it is violating the 4th Amendment rights on basis of search and seizure. Now, my job was to talk briefly about the 8th Circuit. Again, it's had a lot less coverage because it was filed later and it is now on appeal. The matter is on appeal. So I thought it might be helpful to have a map because our United States is broken into a number of different geographic regions and districts. So if you look, you can see on this chart, you can see that the 5th Circuit, which is now the opinion that Daniel was referencing, involves Texas, Louisiana, and Mississippi. So it is found that the enforcement provision in HISA is unconstitutional. Meantime, the 6th Circuit, which includes Tennessee, Kentucky, Ohio, and Michigan, is found that it is constitutional, and there was a writ for certiorari, which is a filing with the court to ask the Supreme Court to review that decision. And that was then denied, and now it is back. Apparently, what I understand is going to be filed again for rehearing based on the 5th Circuit's decision. So we have a 5th Circuit, 6th Circuit that are in conflict, but we also have the 8th Circuit. And that, as you will see on your chart, includes North Dakota, South Dakota, Nebraska, Minnesota, Iowa, Missouri, and Arkansas. And interestingly, that case was brought by 2 party plaintiffs that are here with us today. Judge Walmsley and John Moss of the Iowa HBPA are both party plaintiffs in that case, as is the Iowa's HBPA. It was filed in April of last year. The defendants in the case are the defendants that are in all of these cases, basically the Federal Trade Commission, its commissioners, and then the authority. In litigating cases, one of the things I think you always want to look at is what judge or potential judges you can draw. And in deciding to file the first action in the 5th Circuit Court of Appeals, there was probably some consideration given to the fact that that's a fairly conservative circuit, and that the U.S. Supreme Court wanting to take a crack at this administrative state that Daniel has referenced would probably be a good forum to try to take that challenge to. In this case, if you look at the federal judge in this case at the trial level was James Moody. Judge Moody enjoys an excellent reputation, has the highest degree of education, but is an Obama appointee and has been on the bench since 2013. Judge Moody, I believe, his father was also a judge. He is very well respected and very experienced. There were a number of constitutional challenges brought in the 8th Circuit. So if you look, we've got 4 of them primarily that were advanced. One was a non-delegation doctrine we've talked about. We also have the appointments clause argument that was advanced, the due process argument, and the 7th Circuit argument. All of those have been advanced in this case. So that leaves us with where is the 8th Circuit, because it is looming here and could become a major factor in short order. But one of the reasons I say this is that the 8th Circuit is a bit different than the 5th Circuit. The 5th Circuit Court of Appeals, you'll remember, that case was argued in New Orleans. on October the 10th of 2023. We did not get a decision until July 5th of 2024.
Tell me about it.
So much longer time frame than what the Eighth Circuit typically does. The Eighth Circuit, as a general rule, will decide the case in about 3.7 months. So if we're thinking about when could we get a decision from the Eighth Circuit, it will be relatively soon, roughly October 1st, give or take, because the matter was fully briefed and argued in June of this year. So in connection with the this challenge and the 4 points that we've talked about, the party plaintiffs, Judge Walmsley and John Moss, have asked for injunctive relief. Basically, what they're seeking in their case is to have the HISA rules regarding racetrack safety and the medication rules halted until there can be a decision by this court. They filed their motion for injunctive relief, and the defendants filed a response, and it was argued. And that matter was argued before Judge Moody, and Judge Moody decided, and I think it's important to note what he decided, which was he denied their request for relief, but as importantly, what was the basis for the denial? Well, one of the basis and the mainstay for the basis of the denial in the Eighth Circuit is that the probability of success on the merits, Judge Moody did not see. He did not think that they would be successful on the merits. And he said, if I can't see that, then I can't see going forward and deciding the other issues in the case. Now, with the decision out of the Fifth Circuit Court of Appeals finding that the enforcement provisions of HISA are unconstitutional, I believe that there will be renewed filings in the Eighth Circuit, and I believe that Judge Moody and the Eighth Circuit Court of Appeals may look at this far differently. If they were to follow or be persuaded by the Fifth Circuit's position, then you would be placed in even a more, HISA would be placed in even a more precarious situation with potentially 2 federal district courts deciding that there are constitutional issues with the legislation and 1 not. I would agree with Daniel at that point. I think that there is no doubt that that the Supreme Court would, or very little doubt that the Supreme Court would accept the case for hearing an oral argument. With regard to the Eighth Circuit, the lower matter, the matter's up on appeal. Everything else has stayed until there's a decision from the Eighth Circuit. We anticipate that if you look at just the general period of time the Eighth Circuit takes to decide a case, somewhere around October 1st. One other matter which I was not asked to talk about, but there was a 4th challenge. It was filed in the 10th Circuit, and that matter has been dismissed. So now we're down to these 3 challenges: the 5th, the 6th, and the 8th. I would tell you that I go back to the trying of these cases. For me, listening to the first presenter, one of the problems gets to evidence. And I thought about that many times over when he was making his presentation. If you're representing a horseman, whether it's before a state agency or whether you're representing it before a federal court or the HISA or HIWU board, in that adjudication process, one of the key things that you have to keep in mind is the record. How is that record going to look? How complete is that record going to be if you have to appeal? And one of the concerns is when you're dealing with different sets of rules, it's almost as if the game changes week to week. Are we using the federal rules of evidence? Are we using the state courts, federal, or the state's courts, federal rules with regard to that? Are we using the Court of Arbitration and Sport rules? These have different outcomes. And especially with regard to expert witnesses. And as you know, in medication cases, those cases turn directly on expert testimony. So this challenge, these challenges that we put forth in the 5th, 6th, and 8th circuits are critical to the, I believe, to the future of our sport and our industry. So I'd be glad to answer any questions. Thank you very much for your time.
Thank you, Pete. And just real quickly, I want to give just a quick update. is that a couple of things have happened within the past week. Oklahoma filed a petition for rehearing in front of the Supreme Court, asking the court to reconsider its denial of its petition for cert based upon the Fifth Circuit decision that HISA is unconstitutional. Then other cases to be filed today that's going to be challenged, HISA and the FTC on some other matters we can't get into right now because of the they've asked us to keep it confidential until it's filed. It's supposed to be filed here, like I say, today. Once that happens, we'll be happy to share the details with you. Another case is pending is in the Western District, Louisiana, before Judge Daugherty. And that's one where a lot of the affiliates here are waiting to be added. In that case, it was put on hold by the judge awaiting a decision of the Fifth Circuit. Now that we have a decision, the orders with respect to that case should start to be coming down. As Daniel and Pete both mentioned, the Supreme Court has as the trend is to limit the administrative agencies. We've seen a number of cases. The other case that hasn't been mentioned is Axion Enterprises versus the FTC. That case allows for you to skip the administrative process, go directly into federal court when you're challenging the constitutionality. And there are a number of reasons why the HISA can be challenged on unconstitutionality, which Pete related the different challenges. So I do want to open this up to questions, and Judge
Peter,
had a question to start
Judge
out
Walmsley.
with.
Yep.
Thank you. Let me say, incidentally, I enjoyed this panel discussion about as much as any I've heard in a long time. And I want to thank you all for participating and coming forward so much.
Thanks for being willing to sue them. I always joke, like, the difference between a case and a law review article is a client, right? I have lots of ideas for people I want to sue. Trust me. But it's only when we have people who are willing to actually stand up for their rights that we can do it.
Well, I wanted to address one relatively small point, but one that affects many of these affiliates, and that is the affiliates in the Fifth Circuit case that were not part of the Fifth Circuit. That is, their base was outside the Fifth Circuit. In the event that the ruling in the Fifth Circuit case is not stayed, what rights, and this is the question I get asked all the time by the affiliates who were party plaintiffs in that lawsuit, but were non-residents of the Fifth Circuit. What avenues or what potential avenues do they have for getting relief if that decision is put into force?
Yeah, it's a great question, Judge. So I'll tell you where I'm starting from. So I represent the national HBPA, right? Which has members all across the country. And I always remind courts that the key principle behind the act is uniformity, right? Like, you think about what HISA was supposed to be achieving, and the answer is uniformity. And it's interesting to me, if you go back to the medication order that the FTC issued in the interim after we won the first time at the Fifth Circuit, but before Congress amended the law, when they suspended processing the ADMC, they said, if the rule won't be effective in the Fifth Circuit, well, then we won't do it anywhere because we want national uniformity. And so my goal will be to ask for national relief. I don't know that I'm going to get it, right? I mean, if you go back to the slide that Peter had up, actually, could you put the map up again?
Sure.
If you go back to the slide that Peter had up just a minute ago, you know, I think that the Fifth Circuit is going to be respectful of the fact that the Sixth Circuit went the other way. However, one path forward for relief could be to say, like, I represent not just the national HBPA, but as you point out, 12 individual affiliates that are also organizations, also plaintiffs, and they are also entitled to relief, right? Like, we won. People who win get relief. Conveniently, none of those 12 plaintiffs are in the Sixth Circuit. And so one way that the court could respect the Sixth Circuit's ruling is to just extend relief to the 12 states where there are party plaintiff affiliates. I think it is also possible the Fifth could say, we also need to respect the Eighth Circuit and not want to prejudge what could happen in its boundaries. And so we are going to just limit our relief to the Fifth Circuit. I think that's possible. But certainly what I'm going to push for is, like I said earlier, as much relief as I can get in as many places as I can get. Does that kind of answer your question?
Yes, it does, except tell them what relief is potentially available.
Yeah, so I keep using that term relief. Look, so on the one hand, all the court said was the enforcement provisions are unconstitutional. And so I could imagine a world in which the court says the rules are the rules, but you can't go around invading people's barns, right? Like you have to, you can't exercise your enforcement provisions. On the other hand, like rules that can't be enforced are no rules at all, right? Again, I have a 10-year-old and a 13-year-old. Like rules that do not get enforced are no rules at all. You can't divide the two, right? I think the phrase we would use, Judge, would be, you would know, is like severability. You can't sever rulemaking and rule enforcement. Like the scheme fails if the two pillars aren't both in place. So, I think I'm going to go in there and say, at minimum, like you can't let HISA private investigators go rooting around in other people's barns. Like that's just, you said they can't. You said it's unconstitutional, so don't let them. But the idea that the rules can operate without that, again, like we're just not going to live in a world where you run a race, your jockey uses one too many strikes on a horse, and you get to the end of the race, and they're like, well, your jockey used one too many strikes. And you're like, I am an HBPA member. The rules do not apply to me because I am part of this lawsuit, right? Like that world just doesn't work practically. So I think that's what we're going to explain to the court, like that world doesn't work practically. And so you got to give us relief today.
Would you agree that the dues that these affiliates pay, the horseman's portion of those dues would also be, and the payment of those dues would be an enforcement of a rule?
Yeah, so
we have relief from that.
I mean, it's a great question. It's so I've made two arguments. One is, we talk about legislative delegation, the idea that the authority is doing what Congress can do. One thing that Congress can do is write laws. Another thing that Congress does is pass budgets, right? They set tax rates and they set fees, and then they decide how to spend those fees. Here, the authority is doing that without any congressional oversight, which I think is a problem. There's the second problem that you've pointed out, that the collection of fees and enforcement of fees is an executive function, which seems to have been struck down. And then I'll point out a third problem, which is practically HISA is spending half of its budget on enforcement. Well, if it can't do enforcement constitutionally, why is it collecting that money, right? Like it can't collect the money if it can't spend it on the thing it's spending it on. So again, I think the whole act works together. And if we knock out one of the pillars, then the rest of the act should fall because it's not severable. You can't just cut and slice and dice the different parts of it.
Peter, one last thing, and then I'll sit down and shut up. But I do want us to recognize that we would not be where we are today if it weren't for the existence of legal foundations. If we didn't have a legal foundation that's represented us in the Fifth Circuit, if John and I didn't have the foundation that's representing us in the Eighth Circuit, we wouldn't be where we are. We couldn't have afforded to be there. We couldn't have paid the lawyer fees. So we need to again, keep in mind the foundation that these gentlemen represent and how much we owe them. Thank you so much.
Thanks for saying it. You know, I'll just say two things. One, several of you have actually been supportive individually of the case. If you want to find me afterwards because you want to make a tax deductible charitable donation to support the work we do, either through your affiliate or through your company or individually, obviously I got business cards. So would welcome that conversation. You know, the other thing I'll say is, like, frankly, most of the cost of this case is being borne by other people, right? The people who support my foundation, the other foundations. And the reason they do it is because they realize this case is important, not just for this industry, but for this country, right? The reason that people are generous in supporting our foundation and the work that we do is because they know that ultimately this isn't just about horse racing. This is about the country and the Constitution and these values we hold dear. And so, I mean, I'll just say, as much as it's, you know, I appreciate your thanks, it's also like me saying thank you guys, because it's a privilege to do this work. It's amazing to be able to go up to the podium in front of a bunch of judges knowing that I have two clients. I represent the National Horsemen's Association and I represent the Constitution, right? Like, I have two clients every time I take the podium, and that's a privilege and a joy.
Thank you, gentlemen. John Moss with the Iowa HBPA. I just wanted to say thank you, of course, to three gentlemen in the panel today. You've done a fabulous job. Quickly, though, my question turns to Brent. Yeah. Really wanted to say thank you very much. You've learned, as you've said, a tremendous amount in these last year, 12 months. It's really representative of what us horsemen have tried to avoid all these years, is getting this type of situation where an owner feels so disgruntled that they have to go to the bat for their trainer to this point, just to try to prove their innocence. Todd Mosteller, I always give him credit, executive director for the Pennsylvania HBPA, always described it as getting trapped in a web of innocence. And it's always incumbent upon the owners to try to help out when those situations occur. So Brent, I really do appreciate it. We just talked about the costs that would be exorbitant if organizations, HBPAs, had to take this cost on. And I want to make sure I verify this again. You said you've spent upwards now of $620,000 of your own money.
620,000, and as I said, growing, because we are about to go into federal district court, and I mean, the panel knows what that costs, but you know, the issue we've had is that I didn't get into it, but I'll touch on it briefly. Is that when you try to argue constitutional challenges issues in a administrative situation where the law or the administrative rules favor the authority and give no deference to the individual, that's what drives the cost, because you are pushing the sled uphill. And so you've got to go through this merry-go-round to get to a place where you can then flip it into district court. And it's not easy. I mean, and for the case, you know, with Jonathan, you know, people can like Jonathan, not like Jonathan. That's not the point. You know, as I said before, you take the names off the table. You talk about the facts and circumstances of the situation. And the reality is, you know, if you find yourself afoul of these rules, where the authority, there's nobody that holds the authority accountable. And that's the thing that was missed. And I think in the conversation that I wanted to revisit is that there's nobody in charge. There's nobody holding them accountable. And so there's no place that you can go. You just keep going through this appeal. And then you get to a place where then, okay, you can then try to go to district court to then go argue the merits of the situation of saying, you know, who holds the agency accountable when they don't follow their own rules? I mean, where is the relief? Where do you get relief when they don't follow their own rules? So to answer, sorry, I expanded upon your question, and I apologize. Yes, I've spent upwards of 600,000. I'm prepared to keep fighting because I don't know where this will ultimately end up, but I know that the only way to force change is to hold people accountable and truly force the change if they're unwilling to do it on their own. And so far, they haven't been willing to do it on their own, so you have to force them to do it.
Again, thank you, Brent. Very much appreciate it. I do want to emphasize too that Jonathan's able to fight this fight because of an owner such as yourself. Us as horsemen, as HBPA representatives, we have individuals such as yourself, all the way down to individuals that want to have 1 or 2 horses that can never take on this type of fight. They do not have the means. So we are very much appreciative, once again, of owners such as yourself, and of course, echoing Judge Walmsley's comments about the Pacific Legal Foundation and others that are helping us in this cause for obviously not only horsemen, as Daniel keeps saying, as Americans in general. Thank you.
Yeah, no, I appreciate it. And the great thing about this whole thing is or I should say the ironic thing is, I never knew any of these people before all this started. I was just an owner. I didn't really understand how this industry really totally worked. I've learned a lot. I've never actually met Eric in person. We've spoken on the phone many times over the last year. I've spoken to Daniel several times. I actually saw Daniel face-to-face via a Teams call about a week ago with a couple of my lawyers. But I didn't know any of these people. I wasn't a part of these, I think Eric refers to it as the alphabet soup organizations. I was just a guy having fun with my family. I mean, I enjoy this business. I enjoy this industry. Haven't enjoyed it lately, let me be candid. But I've enjoyed it. But once I found and saw what was happening, and I highlighted it last July, this isn't about me. This is about, hey, the survival of this industry is dependent upon having both an economic model that works, but more importantly, a regulatory framework that is sustainable, and it's equal, and it offers equal protections for all participants. That's what's the missing link, is there's not equal protection for all participants.
Yeah, I echo John's statements. Brent, you've done a world of good for our industry, and I think owners like you who are willing to stand up and fight, we're the bad guys in the room. HBPA is the bad guys in the room. So when we say something, the press takes it one way, but when a guy who has no dog in the fight in terms of being a horseman's representative is willing to put up $500,000+ of his own money, that says something that the press can't ignore. And I don't know that we've actually hit on it today, but Jonathan's case points out the non-uniformity in HISA. The HISA, the people who are supportive of HISA, you were supportive of it largely because it was going to bring uniformity to the industry. And you've got Jonathan, who's been out of commission now over a year, more than $600,000 in the hole, still fighting metformin positive, and you've got other trainers who serve no penalty for that, which I would argue would be the right solution, but it's got to be the right solution for everybody. It can't be the right solution for a guy who got it 8 months after, just because timing was different. So
yeah.
I mean,
we were the second. We were the second case. The first one was a thyroid L case in Florida, and we were the second case that was published once the HISA went live. And so, yeah, I mean, all I can speak to is that, lots been made and said about, how we've adjudicated this case and that we changed our story and Jonathan was discredited and all these other things. It's like, when the factual basis is, we introduced our defense, but we were kept being told that what we were introducing isn't a defense that they would entertain. So we had to keep trying to figure out how are we going to articulate and adjudicate this, because, the fact of the matter is, we know one fact, and that fact is Jonathan Wong did not administer this medication to this horse. And the last thing I'll lead to, and this is a very fundamental thing that has been lost in all this. Every single one of Jonathan's horses, 151 horses, were tested for any banned or controlled substance, and all of them tested clean at the time of his original adverse analytical finding. The other thing I would say, specific to metformin, and every single one of the other metformin cases with every single one of these other trainers, all of their horses were tested. There's never been an instance where another horse in the barn has tested positive for the medication. So what it leads to, which is what I was trying to articulate before, is there is a problem with this ship-in scenario conversation that has to be addressed and fixed, because you can't continue to take someone's livelihood, brand them, and impugn their reputation by no fault of their own.
All right, we have time for one more quick question.
Hi, Danielle, Oklahoma. My question is, and it's kind of like to piggyback off of Judge Walmsley. If, let's say, the Fifth Circuit comes back and doesn't give relief, he only gives relief to the Fifth Circuit. Since we are affiliates, like Oklahoma is an affiliate, is it possible to go to our federal court and say, and since none of the affiliates that are listed on there are in the Sixth Circuit, could we go to our own district and say, hey, the Fifth Circuit ruled this way, and we were a plaintiff on there, we want relief as well?
Sort of. So on the one hand, as a party to this case, your individual affiliate is bound by the case that you're in. And so if the Fifth Circuit issues a ruling that says, you know, we're only going to have relief in the Fifth Circuit, that would bind your affiliate. However, as Judge Walmsley and John Moss's case have pointed out, if individual horsemen who are not technically plaintiffs in my case filed their own case in, say, Oklahoma and said, hey, Oklahoma court, we think this Fifth Circuit opinion is really persuasive and you should follow it. Just like we're currently saying to the Eighth Circuit, right? That would be entirely possible and could have a lot of value. Frankly, I think part of, you know, certainly what we're going to argue is the sooner the Supreme Court hears and decides all these things, the better, because it will prevent having just that kind of mess, right? So when the Supreme Court looks down from on high on the world and sees a mess, that is one of the things that prompts it to intervene. And so my hope is if the Supreme Court, you know, if we can show the court like, hey, you know, again, uniformity is supposed to be the principle here. You need to step in promptly. Certainly, you know, that might be one of the arguments we make to say, we only have relief in the Fifth Circuit right now. So Supreme Court hear and decide the case by June of 25, because rather than June of 26, because, you know, we need expedited relief because all of these states that are not covered otherwise are having their rights violated. So one way or the other, we're going to get as much relief as we can, as fast as we can. I just don't know exactly what it's going to be.
Thank you all for your time. I guess we're out of time right now, but I think we'll be around trying to answer questions on an individual basis if you have any more. Thank you.
Let's give everybody a hand.
Thanks,
please.
guys.